basically including the statement that the guy that bought it, Ferguson, made. Can I get your cell where I could reach you? Okay.
All right, good morning, ladies and gentlemen.
Good morning,
Okay,
Judge.
so I'll, depending on when it comes up, I'll give you
Romero,
text,
we're
and
going to start
I'll
with
update
a
you.
private case. I understand you had a little difficulty this morning.
Traffic.
Glad to see you made it okay.
Thank you.
Yeah, I know. I hear you. The more
that you
details, the
have-
better.
Judge,
But
page 4 of
I'll
your
let you
docket,
know.
Erica Camejo. It's
Okay.
a VOP warrant.
All
She's
right,
at North
thanks. All
Broward, and it's Lila Sandy on her behalf. Judge, I don't know if you
And for
can
the-
set this for tomorrow for Judge Diaz's calendar, or if you would be willing to give her a monitor. She does have a child. She does work. She is in the process of completing all the DUI conditions that she had back. This is an old case in 2012.
I do see that, and I do see that he issued a no bond warrant, and there's a hearing already set on 4/27.
Okay, all right, so we'll keep that date, unless the court
Okay.
wants to give her a bond and a monitor in the meantime.
At this point, I'm not going to disturb Judge Diaz's order,
Okay,
but if you want to set it earlier, you can contact my JA, because she's
I
coming
did,
for his
I
JA.
did, I did this
Okay.
morning, just in
All right.
case.
Oh, that was your number.
Yes.
She wasn't there. I was
Oh,
listening
okay.
to the phone ring.
All right.
I can't pick up the phone. That's an ex parte. But she'll be there shortly.
Okay, no worries, so
And,
427 is fine,
Okay, and it's at 11 a.m.
very good, thank you, Your Honor.
Thank you. Oh, and hold on. I didn't see Miss Camejo.
You want Miss Camejo?
Yes, I just wanted
Miss
to know.
Camejo. She's right here. She was on the phone.
Oh,
Sorry.
okay. She was on the phone with Mr. Reedy.
Yes.
God bless you.
Ma'am,
Hi, good morning.
good morning, ma'am. Your attorney's here, and there's a violation of probation warrant that's set with a no bond hold. You have a hearing before Judge Diaz on April 27th at 11 a.m. Okay?
I'll try to get you in earlier if I can.
All right, Lilas, thank
Okay,
you.
You got it.
And I've already spoken to Ms. Allende about how to expedite that matter, okay?
Thank you.
You're welcome, ma'am. Good luck.
Thank you, Judge.
Take care. All right, Mr. Romero, let me know if you need a moment on, if we get to a case, if you need a moment, let me know, okay?
Appreciate that.
Oh, of course, sir. All right. Marla Williams?
Ms. Williams, come on up. She's here at Maine. She's approaching, Judge.
And for everyone, I'm going to provisionally appoint the Office of the Public Defender to represent you for the purpose of this hearing. And Ms. Williams, I do find probable cause to detain you in reference to one count of misdemeanor battery, it's domestic in nature, and in reference to conditions of release.
State will be requesting a $1,500 bond, Your Honor, no victim contact.
And defense?
Judge, in speaking with Ms. Williams, she's 37 years old. She's been living in our community for the past 30 years. She's currently employed. She works at Jackson's Pharmacy. She's a pharmacy technician. She's been doing that for the past 7 months. She's making approximately $16.34 an hour. Financially, though, she doesn't have that much financial resource. She has no money in the bank, no property. The alleged victim is her husband. She will be living separate and apart from her husband. She'll be living with her family who reside in Davie. The alleged victim and her do share a child in common who's 18 months old. Judge, she's a registered voter. If the state can confirm, this is her first arrest ever, her first exposure to criminal justice system. If that's the case, considering her strong ties to the community, Judge, we'd be asking you to consider an ROR on Ms. Williams' behalf.
Is this her first offense?
Yes, Your Honor. If there was any record, I would have
Okay.
advised the court right previously.
I'm not inclined to release her ROR. I do see another uncharged crime that was stepped out in the probable cause affidavit. I'm not going to make a finding on that. But I will set bond at $1,000.
Judge, one other request. My understanding, like I said, the alleged victim and her do share a child in common who's 18 months old. I know Your Honor is going to order no contact. What I would ask is if you would allow contact for the limited purpose of arranging child visitation through a third party. So therefore, she wouldn't have any direct contact with her alleged husband. They would contact a third person, mutual person, probably her family or her husband's family, and arrange child visitation that way.
Okay. State?
I'm fine with that, Your Honor.
Okay. Ma'am, I will order no contact with the alleged victim in the case. And no contact means no direct, indirect, third party, or telephonic, electronic contact, no social media, anything like that. However, I will allow you to have contact with an approved third party for the limited purpose of the child care issue. Okay?
Thank you, Judge.
Good luck, man.
Oh, wait. Okay.
Thank you.
You're very welcome.
Ashley Joseph.
Mr. Harrison?
Ms. Joseph, good morning, ma'am.
Good morning.
Good morning, and I do see that we have an individual present that's here in court for you. And can we please swear in the witness? Madam Clerk?
Sir. Sir. Right hand. Other hand.
Clear your notes, sir, don't worry. Okay,
My name
sir,
is Sentinel Joseph. I'm Ashley's father.
okay. And you're her father?
Yes.
Ma'am, can you hear that your father is present in court?
Yeah.
Okay. I will give you a chance to speak in just one moment, sir. Ma'am, I do find that there is probable cause to detain you on the one count of assault. And before I hear from the parties as to conditions of release, sir, did you want to say anything?
Yes, I understand that. What I'm trying to say, she's a good kid.
Can you please speak up, sir?
She's a good kid. She don't have no problem. She just, go to school and working. The two sisters have a little agreement in the house. Every child have an agreement in the house. You know, so I don't know. The other one called the police. I wasn't here. When I get home, I tried to calm down. She already called the police. So when the police come in, I try to play with the police, not to arrest her. So you got to arrest somebody. So only thing I ask you, please. This because she's going to school. She get it. She's working. She's 19 years old. So she has no problem. She only having damage. Yeah, like on his sister, that's all. That's all I ask you, please.
Okay. And Mr. Romero, were you able to hear that?
Yes, Judge.
Okay. Now, arguments as to conditions of release?
Your Honor, she has no criminal history. Looking over the facts, it looks like she could have been charged with something more serious. That being said, state will be requesting a $1,000 bond and no victim contact.
All right. I am concerned with the alleged use of the taser. Mr. Romero, did you have anything? Mr. Linder did ask for a $1,000 bond, is that correct?
Yes, Judge.
And no victim contact.
If I could give you a little background, as Mr. Lender did say, this is her first arrest ever. She's 19 years old. As her father did confirm, she is working, going to school. She just started her employment at Target. She's going to school at Broward College. She is a sophomore. She's studying criminal justice. She has family who lives in her community. My understanding is that the actual sister moved out. I did advise her she's supposed to have no contact. So if that's the case, the sister did move out, she would be going back to reside at the family home. Judge, considering this is her first offense ever, I'm going to respectfully be requesting an ROR on her behalf.
I would just add that, Judge, according to the probable cause affidavit, the victim stated she was not willing to prosecute.
Okay, I don't have the victim present this morning. But I am concerned based on the nature of the offense. So I will issue a $1,000 bond and order no contact with the victim until further order of the court, ma'am. And that means no direct, indirect, third party, electronic, telephonic, or any other means, okay? So no contact with the victim. And no weapons in addition to that. Okay, ma'am?
Okay, yes, Your Honor.
Good luck, ma'am.
Thank you.
Yes, sir. Good luck as well. And do we have Esteban Mayor Fernandez?
He's here present, Judge. He's going to be requiring a Spanish interpreter.
And okay, we don't have one as of yet. We'll place that on recall.
Okay.
Mr. Reedy went ahead and ordered that, the interpreter. So we'll go to Mr. Boza.
Mr. Boza as well is going to require a Spanish interpreter.
Okay, we'll place that one on recall as well. Sabran Nixon.
Mr. Nixon, come on up, please.
Good morning, Mr. Nixon, sir.
Good morning.
So you have two counts that have been presented against you. One is battery. The other count is resisting without violence. Sir, I do find probable cause to detain you. In reference to conditions of release, state.
Yes, Your Honor. Your Honor, I see no criminal history. Based on the allegations in the report, the state would be seeking a $2,000 bond, no victim contact.
Okay, and defense?
Judge, it's being Mr. Nixon. He's 24 years old. He's currently employed. He works at the local golf course in Hollywood at the restaurant called Rudy's Restaurant. He's been working there for 1 year now. He's a cook. He's making approximately $10 an hour. Financially, he has no money in the bank, no property. The alleged victim is his girlfriend. They do live separate from what he advised me. She resides in Pembroke Pines. Yes, in Pembroke Pines. He resides in Hollywood. Judge, we'd be asking you to set, considering his financial resources, I'd be asking you to set count one at $1,000 and count two, leave it the standard bond, which is currently set as no bond necessary, Judge.
I would just add, Judge, that according to the victim's report to the officer, they've never had a physical altercation in the past. This was the first time.
Okay, I will set bond at $1,500 on count one.
Do you have any children?
And 0 on count two. It's R on count two. And no contact with the victim. Sir, that means no direct, indirect, telephonic, electronic, third-party contact by any means, sir. Okay? All right.
One additional request, Judge. We'd be asking you if you would sign a photo order allowing us to photograph Mr. Nixon's injuries.
Absolutely, sir. As soon as one
Thank
is
you.
provided, sir.
Thank you, Judge. Okay. Akeem Harrison.
Young man, you done? You done? Go down the middle.
What happened?
Mr. Harrison, good morning, sir.
Hold on 1 second. I'm sorry. I'm just
Good morning.
also.
Judge, Mr. Harrison declined public services. I believe he has private counsel.
Okay.
I decline public.
Sir,
This lady, man.
Sir, I previously provisionally appointed the Office of the Public Defender to represent you for the purpose of this hearing. Do you have private counsel that you've retained in this case?
Yes, private counsel.
Okay.
Do you have a private attorney that you retain, sir?
I ain't get in contact with him, so I don't know what he's doing.
Okay, so for the purposes of this hearing, do you intend to represent yourself? For this bond hearing, sir?
Yeah.
Okay, and you
If
understand?
I can't get a public defender, I'll represent myself.
Well, I did provisionally appoint the Office of the Public Defender, but you just asked Mr. Romero to leave the podium.
No, I ain't telling him leave. I don't know. I ain't getting in contact with my lawyer, so I said I use a public defender, but I don't know what's going on.
Judge, I believe he's changing his mind. I know I talked to him, my colleague talked to him. He advises that a private counsel, he said on several occasions that he was declining our services, but now it seems like he's changing his mind, so I'm ready to go forward.
Okay. Thank you, Mr. Reedy.
Hold on 1 second.
All right.
Yes,
Sir, I do find probable cause to detain you on one count of domestic battery. And in reference to conditions of release.
Number to get the phone to the assistant. Can you give me your cell number? Yes, Your Honor. And this year, Mr. Harrison was arrested for battery. And just seeing who the alleged victim was. That was against a different alleged victim. That was dropped. It was domestic in nature. Last year, he was arrested for aggravated assault with a deadly weapon. That again was against a different alleged victim. That was dropped in 2015. He was arrested for violation of a domestic violence injunction and aggravated assault with a deadly weapon. The ag assault was dropped. The violation of the injunction, he pled to and received a withhold. The alleged victim in this case was one of the named victims in that case. And lastly, he was arrested for domestic violence battery against the same alleged victim as, I believe, the 2017 case. That was dropped. Your Honor, based on his 4 prior domestic violence arrests in just the past 2 years and this new allegation, Your Honor, the state is going to be requesting a $7,500 bond and no victim contact.
And defense.
What's that?
Judge, in speaking to Mr. Harrison, he was actually born and raised here in our community. He's 20 years old. He's currently working. He works with his aunt in catering. That job does fluctuate from what he tells me. It's whenever they get like a job, that's when he goes. So therefore, it's not something steady. Last time he actually got paid was about $400 for the week, but it's not something that he gets every week. Financially, he has no money in the bank, no property. The alleged victim, I believe, is his father. He'll be living separate and apart from the alleged victim. He's hoping he's going to be contacting his aunt, who he still has some sort of communication with, to help post his bond. So therefore, Judge, we'd be asking you to consider a $2,000 bond on Mr. Harrison's behalf, and we would also ask you to sign a photo order allowing us to photograph Mr. Harrison's injuries.
Okay, and Mr. Linder, all the prior allegations were dismissed, correct? There were no process?
Yes, everything was except for the violation of the injunction.
Okay. Sir, we'll set bond at $2,000 and order no contact with the victim. It's no direct, indirect, telephonic, electronic, third-party contact by any means, sir. And further, I will order that you not possess any weapons. Good luck, sir.
Thank you.
My handwriting, I'm sorry. Kristen Parrish.
Mr. Parrish is approaching.
Good morning, sir.
Good morning.
Mr. Parrish, 1 count of domestic battery has been presented against you, and I do find probable cause to detain you, sir. In reference to conditions of release.
Your Honor, Mr. Parrish was previously convicted in 2008 robbery with a firearm or deadly weapon and burglary of a conveyance. He violated his probation, was sentenced to 4 years state prison. Additionally, I see previously in 2010, he was arrested in the state of Georgia on a fugitive warrant. In, get into that. Loitering and prowling in 2007, based on his previous violent prior that he went to prison on and the allegations, Your Honor, the state would be requesting a $3,000 bond, no victim contact.
Okay, and defense.
Judge, in speaking to Mr. Parrish, he's 28 years old. He's been residing here in Florida his whole life. At this time, he's unemployed. He's currently looking for work. Last time he worked was last year. He worked at a company called Ferguson. He was a forklift operator. He was working there for about 8 months. He was making approximately $12 an hour. He has no money to make, no property. The alleged victim is his girlfriend. He will be living separate and apart from her. He has family that live in our community. He'll be staying with his brother. That's who he's hoping to contact to help post his bond. Judge, we'd be asking you to set up $1,500 on Mr. Parrish's behalf.
Okay. Based on the level of violence and the priors and also the fugitive warrant from 2010, I will set bond at $3,000. And I will order no contact with the victim, so there's no direct, indirect, third-party contact, telephonic, electronic, by any means, sir, okay?
Yes, sir.
Good luck, sir. My ladies, Kuzo. 3,000.
Judge, we're gonna need a Spanish interpreter.
Oh, okay. I'll place this on my recall as well. Marianne Valenis.
North Broward.
North Broward. Come on in, Miss Jones.
Good morning, ma'am. Ma'am, 2 counts have been presented against you: possession of cocaine and possession of drug paraphernalia. Mr. Linder, was there any other cocaine aside from the Valtox positive tested pipe?
Doesn't appear so.
Okay. Ma'am, I'm not gonna find probable cause on count 1. I'm finding probable cause on count 2. Possession of paraphernalia.
And, Your Honor, just to advise the court for bond purposes, her criminal history: 2016, possession of heroin, violated probation, sentenced to 90 days county jail. 2014, possession of cocaine, 270 days. 2013, unlawful use of false name ID. 2012, burglary of a conveyance and grand theft with a VOP, a year and a day state prison. 2012, grand theft with a VOP, a year and a day state prison.
Okay.
Judge, Miss Villainous has been living here for 5 years. She's currently looking for work. She's given me the phone number of her mother, who I'm trying to reach. She believes her mother can assist her in posting bond. Considering it's a possession of drug paraphernalia charge now, I'd ask for a $250 bond.
I will set bond at $500. And, ma'am, I do wish you good luck.
Thank you.
Our count 1.
So-
Yes, ma'am.
Is that's a misdemeanor now, or is this
That doesn't mean that the charge is going to be charged that way. That's what I found probable cause on, ma'am. Okay? So you don't have to speak today. But anything you say is being recorded. Keep that in mind, okay?
No, I understand. I'm just trying to figure out what it is. That's all.
This is just the probable cause determination. This is what I found probable cause on in terms of what is holding you and what is not holding you.
Okay, so it's
That
just a paraphernalia.
That does not stop the state from filing the possession of cocaine charge, okay? So that
Correct.
could,
No,
that
I
could
was
be
just-
filed.
Okay, I was just trying to figure out exactly what it was I was being charged with today. That's all.
Okay, ma'am.
What you found probable cause on. That's all.
All right, yes, ma'am. I did find probable cause on a possession of drug paraphernalia.
Yes, sir.
Good luck, ma'am.
Thank you.
You're very welcome.
Hey, it's Eric Linder.
Amanda Marquise.
North
in
Broward
North
again,
Broward.
Your
Good morning, ma'am.
Good morning, how are you?
Ma'am, you have 1 count of drug paraphernalia and 2 violations of probation that have been presented.
Yes.
And I do find probable cause to detain you.
I'll call Secretary.
Paraphernalia, I will set a $100 bond. The violations of probation have already been set at no bond.
Yes.
17.
Okay, you do have a hearing on 4/27/17. That is in 2 days at 8:30 a.m., ma'am.
Okay, thank you.
You're very welcome. Okay, Chelsea Wiggins.
All right.
Miss Wiggins,
Yes.
good morning, ma'am.
Good morning.
Ma'am, 2 counts have been presented: grand theft and uttering a forged instrument,
Yes.
and I will find probable cause to detain you. In reference to conditions of release?
Judge, as to probable cause on count one, it seems that this transaction was nipped pretty much right in the bud. It doesn't look like she ever took any possession of any money.
The statute is obtain or endeavor to obtain.
I understand.
So I will find probable cause, but in relation to conditions of release, though.
Judge, Miss Wiggins has been living here for about a year. She's down here from Georgia. She does have family in the area. She has her aunt and her grandmother are here. She has $250 in her property that she could use toward bonding herself out. She graduated from high school last year. She stays in West Palm Beach with a roommate and has a stable address. She's provided me with the name and number of her aunt, who I can contact to assist her in bonding out. And my understanding is that she has absolutely no prior criminal history whatsoever. So I'd ask the court to consider reducing the counts, the $1,000 bond, maybe make it $500 per count.
Okay, Mr. Linder.
Your Honor, I was just going to be asking for the convenience bonds to be kept in place.
Okay. Ma'am, I will set bond at $1,000 on count one, $500 on count two.
Angel.
And I'll call your aunt for you, okay?
Okay, thank you.
And Mr. Reedy, do you need an order to access her property?
Just see it, but here's another case you.
James Owens.
James Owens is approaching, Judge. He declined to serve as public defender.
Good morning, Judge.
Mr. Owens. Good morning, sir.
You, sir.
Good to see you.
Good to see you too, sir.
All right, sir, you have a capias issued in the amount of $1,000 for failure to appear before me.
Yes, sir, before you.
Yes, sir. You do have a future court date. I am finding probable cause to detain you. And I do recall the circumstances of the failure to appear. You have a future date of May 3rd, 2017 at 9 a.m.
All right, sir, we'll do.
Okay? All right,
Thank
sir.
you
I'll see
very
you
much.
then. Good luck.
You have a good one, sir.
You as well. And you have a $1,000 bond, sir.
Mr. Owens, you can go down the middle outside. Down the middle.
Troy Upperwood.
Mr. Suazo?
Yes, sir. Yeah, just have a seat in the hallway.
Good morning, sir.
Good morning, sir. How are you?
Pretty good. How about yourself?
Doing well, thank you. Sir, you do have a warrant issued for your arrest in the amount of $500.
Yes, sir.
And I do find there's probable cause to detain you, sir. And that's on case number 170004662MM20A, sir. Okay? Good luck, sir.
Do you have any children? Put a zero, press down hard.
And Jonathan Taylor.
Jonathan Taylor, come on up.
Hold on to the paper with your other hand. Okay, now.
Good morning, sir.
Hello, sir.
Doing well, and yourself?
Huh?
Doing well, how are you?
I'm doing okay.
Sir, you have two counts that have been presented. One is operating a motor vehicle without a valid driver's license. The other count is a warrant that was issued for your arrest in the amount of $250. And sir, I do find that there's probable cause to detain you. Any argument as to conditional release on count one?
I'm just asking that the bonds be kept in place, Judge.
Okay. Defense?
Nothing from the defense.
Okay, I'll set bond at $25 on count one. Bond has already been set at $250 on count two.
Thank you, Judge.
Okay,
Good luck, sir. We do have a Spanish interpreter present.
Good morning, Judge.
Good morning. And we'll be recalling the cases that involve the Spanish interpreter. Madam Clerk,
Okay.
please swear in the interpreter.
Esteban Meyer Fernandez.
Igor Feliciano.
Okay, do you solemnly swear that you shall, from the students of
So the interpreter for this court is a true translation from Spanish to English.
I do.
Okay, and the first case we're calling, Mr. Romero, is?
Esteban Mayor Fernandez. He's on page 2. I believe it was the third gentleman when we started the docket.
I do have the case before me.
Tengo el caso frente mío.
Sir, you have one count of domestic battery that was presented against you.
Señor, usted tiene un cargo de agresión doméstica que fue presentado en su contra.
And I do find probable cause to detain you, sir.
Y hallo una causa probable para detenerlo en este momento.
In reference to conditions of release, state.
En referencia a las condiciones para la liberación, Fiscalía.
Your Honor, I don't see any criminal history. I'm going to be asking for a $1,500 bond and no victim contact.
Ok, en referencia, vemos que no hay historia criminal previa. Vamos a pedir por una fianza de $1,500 y que no tenga contacto con la víctima.
What county?
Judge, and speaking, Mr. Mayor Fernandez, he's 35 years old. He's employed. He works at the Double Cross Tattoo Parlor, which is located in Fort Lauderdale. He's been working there for approximately 3 years. He makes on an average about $600 per week. Judge, the alleged victim is his wife. He'll be living separate and apart from her. He'll be residing with his father, who resides in Sunrise. As the state can confirm, this is his first arrest ever. He's going to be contacting his father to help post his bond. We'd be requesting a $500 bond.
El señor Mayor Fernández tiene 35 años de edad. Como mencionaron anteriormente, no había sido arrestado. Él trabaja en el Double Cross Tattoo Parlor en Fort Lauderdale. Lo ha hecho por alrededor de 3 años. Él hace alrededor de $600 a la semana. La víctima, la alegada víctima, la supuesta víctima en este caso, es su esposa. En este caso, él va a estar viviendo totalmente separado de la víctima con su padre, que reside en la ciudad de Sunrise, y él va a ayudarlo a poner la fianza.
Okay. Sir, I will set bond at $1,500 and order no contact with the victim in the case.
En este caso voy a ordenar que haya una fianza de $1,500 y ordenar que no haya contacto con la víctima para este caso.
And no contact means no direct, indirect, third party, telephonic, electronic, or any other means, sir.
Y esta orden de no contacto incluye cualquier contacto directo, indirecto, cualquier contacto telefónico, cualquier contacto mediante terceros y cualquier contacto mediante vía texto o cualquier medio electrónico.
That includes a third party.
Y eso incluye también terceros.
Good luck, sir.
Buena suerte, señor.
Next gentleman, Judge, would be Jose Boza. He is on page 2 of your docket. Jose Boza. Judge, he declined the service of public defender. He advised me that he was going to hire a private counsel.
Pues él ha declinado los servicios de un defensor público. Él va a procurar un abogado privado.
82.
Currently? Okay. Sir, you don't have an attorney right now. Is that correct?
Señor, usted en este momento no tiene un abogado. ¿Eso es correcto?
Escucha.
On a different case? All right. Sir.
Ya lo he escuchado.
I didn't catch that.
Can you repeat it?
Señor, ¿es correcto que usted en este momento no cuenta con un abogado?
No, no tengo un abogado aquí.
No, I don't have a lawyer here right now.
Okay. I provisionally appointed the Office of the Public Defender to represent you for the purposes of this hearing.
Para los efectos de esta audiencia, yo provisionalmente he designado a la oficina del defensor público para defenderlo en este momento.
Judge, he's having a hard time hearing. Let me try and help him if you can give me a moment.
Okay. Hold on for just a moment. You have paperwork for me to review? Oh, okay.
I was, because usually we print out the office, but we don't have that because it happened 2 days ago. This is the date of the home. It's the same victim, the same charge.
And, Your Honor, I have.
Hold on. We're not there yet. He's discussing with Mr. Romero.
Oh, yeah, free, bottom, you want free, okay?
Judge, thank you. I've had an opportunity to speak with Mr. Bosa.
Le
Okay.
agradezco por la oportunidad para hablar con el señor Bosa, señor.
And, sir, did you want Mr. Romero to represent you for the purpose of this hearing, sir?
Señor, ¿usted desea que el señor Romero lo represente para los efectos de esta audiencia?
He's having a hard time hearing, Judge. But he wants me to help him today.
Él está teniendo problemas escuchando, su señoría, pero él quiere que yo lo represente el día de hoy.
I need him to be able to hear what's being said.
Yo necesito que él pueda escuchar lo que está siendo dicho en este momento.
Judge,
I can't hear.
Judge, respectfully, he's we're quite quiet here. Unfortunately, I believe he has some sort of hearing difficulty. He might be the perfect candidate to actually have an in-person magistrate hearing, so that he can partake in his own magistrate hearing.
Señor, el señor tiene respetuosamente, el señor tiene un problema de escuchar. Yo creo que él es un candidato perfecto para tener una
Would we be
audiencia
able
de
to
persona.
have the phone placed to his ear?
¿Será posible ponerle el teléfono en el oído?
We could attempt to do that.
Okay.
Vamos a intentar eso.
Is he gonna call or are we gonna call him?
Call. Oh, Judge, which phone would it be? From the bench's phone?
0648, Hector.
Oh, okay, from Mr. Reedy's. Okay, cool.
It's gonna be a very popular line, Mr. Reedy. It's gonna be a very popular line.
Aló. No, escucha.
You're gonna talk on the phone to him.
Okay, he's on the phone right now with the interpreter, so let's see if this way works.
Can you hear now, sir?
¿Puede escuchar ahora, señor?
Sí, lo escucho ahora.
Yeah, I can hear you now.
Okay, and do you want to have Mr. Romero represent you for this hearing?
¿Usted quiere que el señor Romero lo represente en esta audiencia?
You get assistance from the.
No, bueno.
Do you own any property?
Please repeat.
¿Usted quiere que el señor Romero lo represente en esta audiencia?
That's 15, or here, that's 20.
The gentleman standing next to you, sir.
El señor que está parado al lado suyo es el señor Romero.
Yo no entiendo nada de lo que dice.
I don't understand anything he's saying.
It's all gonna come back.
Judge, I don't know if he can't hear or he can't understand Spanish at this time.
Sir,
Él me ayude,
I need help.
ayúdeme. No. Yeah, he said he wants to.
I can't hear.
sir, can you hear in that ear?
Señor, de ese oído sí escucha.
No sé lo que dice.
I don't know what he's saying.
What who
No sé lo que
say?
dice.
Lo que dice quién?
¿Puedes escuchar?
No puedo escuchar.
I can't hear. Who can help
Es
me?
mejor.
I think you
Tú
can help me.
tienes
It's
que
better.
escuchar el intérprete para que escuches lo que yo estoy diciendo. Para que cuando ellos están traduciendo a español, tú tienes que entender qué es lo
They
que
have an
están
interpreter
diciendo.
over there so they can help you when they speak in
Es que
English.
está
He can
hablando allá y
translate.
está hablando aquí y no lo oigo.
They're talking over there and they're talking over here and I can't hear.
He's hearing that and that, and he should turn off and then talk.
Are there two devices playing at the same time that's causing a problem?
Puede ser que haya dos aparatos al mismo tiempo creando problemas.
I know the volume from where the television is coming. I don't know if that's in some way hindering him when the interpreter is talking through the telephone.
No sé si el teléfono el volumen de la televisión interfiere a que él entienda.
I'm going to turn off the mic over here. Let me know if it's better.
Voy a apagar el micrófono acá. Hágame saber, señor, si es mejor.
Is that better, sir?
¿Usted escucha mejor ahora, señor? Yeah, now I can hear a little bit.
Okay.
Okay.
Would you like to have Mr. Romero represent you for the purpose of this hearing, sir?
¿Usted quiere que el abogado Romero lo represente en esta audiencia? Fine, let him represent me.
Okay, sir, I do find probable cause to detain you on the count of violation of injunction.
Señor, hallo que hay causa probable para detenerlo en su violación de la medida cautelar.
Your Honor, the defendant is currently being supervised
I
on
went to look for medicine.
pretrial services in case 17-3699 MM10A. He was released to pretrial supervision. This cause, we ask that his pretrial status be revoked at this time. It should be noted, he's on.
Yeah.
Señoría, hallamos que hay causa probable en este momento. Él fue para el caso 1733699MM10A. Speak louder, because I can't hear. Con su condición de prejuicio fue hallado por el señor juez Gottlieb el domingo, abril 23. Nosotros en este momento hallamos vista su condición de pretrial, de prejuicio, que su estatus de pretrial sea revocado en este momento.
I apologize. It's the same case and the same victim.
Es el mismo caso y la misma víctima.
Same charge, I misspoke.
Y es el mismo cargo.
Judge, respectfully, regarding that case that he's currently out on supervision, could Mr. Lunder see who's his attorney of record on that case?
Respetuosamente, su señoría, en ese caso en el que se encuentra afuera, afuera bajo supervisión, ¿podríamos ver quién era el abogado en ese caso? I can't hear that.
Your Honor, just so you know, this happened on Sunday. I got to use the public defender. There is no attorney on record.
Oh, he's got a translator. I understand.
And, Your Honor, if I may, for record purposes, I've provided the court also with a copy of the probable cause affidavit from over the weekend.
Okay.
Para los efectos del acto, su señoría, yo presenté una declaración jurada de la causa probable que fue presentada durante el fin de semana.
And a copy of the victim's petition for the injunction.
Una copia de la petición para la medida cautelar de la víctima,
Which contains her sworn affidavit.
que que es una declaración jurada,
so the court can be aware of the underlying issues.
para que la corte esté al tanto de los asuntos que están en el trasfondo.
And I provided your copies to Mr. Reedy so he could review them.
Y le suministré copias al señor Reed para que las pudiera revisar, lo cual yo ya las revisé.
Okay. Any
Judge,
argument as to conditions of release on both cases now?
Yes, Judge. From what Mr. Bosa advised me, he's been residing in our community for the past 50 years. He does have a business in Davie, which is located in Broward County. He's a restaurant owner.
Él tiene un negocio que está ubicado en Davie, en el condado de Broward, en un restaurante.
See,
Yes.
the alleged victim on this injunction is his wife. My understanding is they're currently going through some sort of separation.
La víctima, la supuesta víctima de este caso, entiendo que es su esposa. Entiendo que en el momento actual están transcurriendo por algún tipo de separación.
He's since moved out of the home. He's actually residing in Miami, Florida.
Desde ese momento él se mudó de la casa y actualmente está viviendo en Miami, Florida.
Judge, I believe I wasn't present at his initial magistrate hearing. He understood that he had to move out, so he's made arrangements to live somewhere else. I don't know how thorough or whether or not Mr. Bosa understood what no contact meant, because you could see from the issues we're having this morning, just to try and communicate whether or not he hears us, took about 15 minutes.
Yo no estaba presente en la audiencia inicial del señor Bosa. Yo creo que él entendió que solamente se tenía que mudar de la casa y por tanto hizo los arreglos necesarios para hacer eso de mudarse de la casa. Sin embargo, no lo que implicaba la orden del otro ente, visto que los problemas que hemos tenido hoy día, porque el señor Bosa nos escucha bien, tomaron más de 15 minutos.
We appreciate the time this court is taking to make sure Mr. Bosa could hear what's going on today and to understand, and being patient with Mr. Bosa and the defense. I don't know how thorough or detailed that was in his initial magistrate hearing. Therefore, respectfully, I would ask you to impose a reasonable bond on this case and not revoke his pretrial release conditions on the outstanding case.
Nosotros apreciamos los esfuerzos y el tiempo que se ha tomado la Corte y la paciencia que ha tenido la Corte con el señor Bosa y con la defensa para asegurarnos que él entienda y escuche bien lo que está pasando. Sin embargo, no estoy seguro cómo fueron, qué tal la calidad de sus esfuerzos durante la primera audiencia de magistrado con el señor Bosa. Por lo tanto, en este momento, y basándonos en eso, me gustaría que no fuera, yo solicitaría que su condición de revisión no sea revocada en este momento, basándonos en esa posibilidad.
Respectfully, I have reviewed the packet.
May I just add one thing, Judge?
¿Pudiera agregar algo, su señoría?
Mr. Bose is 82 years old. It appears that he went to the residence to collect clothing, and I think he may have mentioned something earlier about collecting medicine.
And a firearm.
I don't see anything about a firearm
In the affidavit.
probable cause affidavit. I know I saw that he owns a gun in the affidavit. I'm sorry.
In the affidavit, and that's what,
Quisiera agregar que el señor Bosa tiene 82 años y que estaba yendo a su residencia. Creo haber escuchado que él mencionó algo acerca de ir a buscar ropa y medicina y armas. No, yo no escuché nada, yo no leí nada de las armas. Yo no sé si en este momento en su declaración jurada.
And it also appears as though the victim was not at home when Mr. Boza went to the residence.
Y también aparece ser que la víctima no se encontraba en la casa cuando el señor Rosa fue a la residencia.
Okay, I've now heard from two attorneys for the defense, the state, and I've reviewed all the paperwork on both cases.
He escuchado de dos abogados de la defensa y de la fiscalía, he revisado todos los documentos para tomar mi decisión sobre el caso.
Sir, on case number 17003699, MM10A,
Señor, en el caso 17003699,
I am revoking your pretrial status.
voy a revocarle su condición de prejuicio.
I'm setting bond at $6,000.
Estoy fijando la fianza en $6,000.
And on the case before me today,
Y en el caso presentado ante mí el día de hoy,
I am setting bond at $2,000.
estoy fijando la fianza en $2,000.
Your Honor.
And I am ordering further that there be no contact with the victim,
Adicionalmente ordeno que no haya contacto con la víctima.
no direct, indirect, third party contact by any means.
Esto implica que no haya contacto directo e indirecto mediante un tercero, es decir, ningún contacto bajo ningún medio posible.
Further, if he needs to retrieve any property, he must do so with the assistance of law enforcement.
Si usted necesita recuperar algún tipo de propiedad, usted debe hacerlo ayudándose con alguna persona.
He may not return to the residence without further order of the court.
No podrá volver a su residencia sin alguna orden emanada de la corte.
Your Honor. The state is going to request, in addition to the bond amounts, that should Mr. Boza post these bonds, he be placed under the supervision of pretrial release services with a GPS monitor.
Respectfully, based on what I've heard, I will deny that request.
And Your Honor, then, if just for record purposes, the state would object. There's been multiple threats alleged by Mr. Boza to kill the victim in the past, in the recent past.
Para los efectos del acta de la Fiscalía va a afectar esta decisión, siendo una presión frente a esta decisión. Han habido múltiples datos de que la víctima ha amenazado con asesinar a la persona en el pasado reciente.
There is little reason to have any confidence that Mr. Boza will follow this court's orders to stay away from the residence.
Hay pocas razones para pensar que el señor Boza va a seguir estas órdenes de mantenerse alejado de la víctima.
And the state believes a GPS monitor is a reasonable request to ensure the safety of the alleged victim.
La Fiscalía considera que el GPS es una solicitud razonable para asegurar la seguridad de la víctima.
I believe that's a matter more appropriately addressed with his trial court or courts plural. And I have ruled.
Thank you, Judge.
Good luck, sir.
Judge, may I have like 30 seconds just to explain to my client, make sure he understood the conditions?
Yes, sir.
Thank you.
We have one more. Thank you.
Is there another Spanish or no?
We have one last. Kuso. Yes. All right, I have the packet here.
What's the name again?
C-O-U-S-O.
C-O-U-S-O, Coso, okay. No problem.
My ladies.
Thank you. Coercion by ladies. Here we go. Thank you.
Thank you, Judge.
Okay.
I believe we have another Spanish interpreter case.
Yes, sir. One last case.
Milady Cuso?
That is it. Good morning, ma'am.
Buenos días, señora.
Get out of here, man.
Ma'am, 4 counts have been presented against you.
Señora, cuatro cargos han sido presentados en su contra.
Possession of cocaine,
Posesión de cocaína,
driving under the influence,
manejar bajo la influencia
and enhanced driving under the influence,
y manejar bajo un cargo de manejar bajo la influencia avanzado
and failure to use due care.
y ausencia de los cuidados necesarios.
Ma'am, I do find that there is probable cause to detain you.
Señora, hallo que hay causa probable para los cargos.
In reference to conditions of release.
No, in speaking with Cuso, she advised me that she's going to contact her father, post her bond. The only request is we'd be asking you to sign a phone order, Judge.
I'm sorry, I didn't catch any of that.
Oh, I'm sorry. I apologize. Our only request is if you could sign a phone order so she can access her phone to get the contact number of her father so he can post her bond.
Nuestra única petición en este momento, señoría, es que usted emita una orden de teléfono para que ella pueda acceder a su teléfono y contactar a su padre para ayudarla a poner el dinero de la fianza.
And I will sign an order indicating that she may have access to her phone to view numbers under the supervision of the Broward Sheriff's Office.
Voy a firmar la orden para que ella pueda tener acceso a su teléfono únicamente para que pueda ver números telefónicos en el teléfono bajo la supervisión de un oficial del departamento del sheriff de Broward.
And State, did you have any argument for bond?
No, Judge.
¿Estado tiene algún argumento en contra de la fianza? No, señoría.
Ma'am, I will set bond on count 1 at $1,000.
La fianza para el cargo número 1 será de $1,000, señora.
Count 2 at $500.
El cargo número 2 tendrá una fianza de $500.
Count 3 at $1,000.
El cargo número 3 en $1,000.
And I will ROR on count 4.
Y la voy a liberar bajo su reconocimiento para el cargo número 2.
Good luck, ma'am.
Buena suerte, señora.
Español, ¿alguien más español? Que habla solamente español. Nobody else at Maine requires Spanish interpreter.
Okay. Can you make that announcement for all the facilities?
¿Alguien más necesita servicios de intérprete en español?
Judge, I've spoken with everybody at the other jails, and nobody else needs a Spanish
Okay,
interpreter.
I just wanted to make sure there was a response.
Judge,
okay.
And he
All right.
declined, by the way.
Sir, thank you.
Judge,
Oh.
we had somebody way back that didn't hear me that requires a Spanish interpreter.
They didn't hear you. But they were able to hear the interpreter. Okay.
¿Qué es tu nombre? Angel. Page 13, Angel Barnica, Judge.
Okay.
Okay, that is the robbery firearm.
Ese es el robo con arma de fuego.
Okay, sir.
Sí, señor.
You have 5 counts that have been presented against you.
Usted tiene 5 cargos que han sido presentados en su contra.
You take medication?
Robbery firearm,
Robo a mano armada,
burglary of a dwelling or structure, armed,
robo de una localía o una estructura armado,
grand theft of a firearm,
robo de una arma de fuego,
grand theft of a firearm,
robo de otra arma de fuego
and grand theft.
y robo.
And state,
Yes, Your Honor.
Fiscalía.
you stood up, I assumed you had
Oh,
something to say.
Your Honor, just to inform the court, the state is seeking a no bond hold on counts 1 and 2, relying on the probable cause affidavit, Your Honor. Sorry.
Buscamos que haya una detención sin fianza en los cargos 1 y 2, basándonos en la declaración jurada de causa probable.
And the 4th DCA's holding in Brackett v. State.
Y que haya una detención en el bracket del Estado.
That proof is evident or presumption great that the defendant committed the offenses of robbery with a firearm.
Y tenemos prueba que es evidente que el acusado cometió el robo con una arma armada.
Armed burglary of a dwelling.
Y el robo de una localía.
The elements contained in the affidavit satisfy the offenses.
Los elementos contenidos en la declaración jurada satisfacen los elementos de la ofensa.
And I would argue that the physical evidence obtained and the defendant's post-Miranda admission providing a full detailed confession.
Y la evidencia física obtenida y la confesión obtenida luego de haber leído los derechos Miranda
would satisfy the state's burden.
Satisface la carga de la prueba del Estado.
And so the parties are aware, it appears that this was a juvenile case that
Parece ser que un caso juvenil
has been transferred to an adult.
que ha sido transferido a
Yes,
mayoría de edad.
Because he was previously being held at the Broward Regional Detention Center,
Asumo que él estaba siendo detenido en el detención regional de Broward,
meaning that he would have already had a detention hearing where probable cause was determined.
lo cual implica que ya debió haber tenido una audiencia de detención donde se determinó la causa probable.
I don't think there's much of a probable cause argument to be made based on this probable cause affidavit in any event, Judge.
No hay argumentos para la causa probable basándonos en esta declaración jurada de causa probable que tenemos.
Any argument as to conditions of release?
Judge, our position would be that the only thing presented to the court so far this morning is a probable cause affidavit. The state is asking for Mr. Barnesia to be held without bond.
Lo único que hemos recibido el día de hoy es una declaración jurada de causa probable. La Fiscalía está solicitando que el señor Barnica sea detenido sin fianza.
We'd be asking for the court to hold an Arthur hearing at this time.
En este momento solicitaremos que la Corte tuviera una audiencia de tipo Arthur.
Would be our position under the Florida Constitution
Nuestra posición bajo la Constitución de la Florida
and State v. Arthur,
y el caso, la jurisprudencia Estado versus Arthur,
that the standard of proof evident presumption great cannot be reached based solely on the presentation of a probable cause affidavit.
que la prueba de un delito no puede ser basada exclusivamente en la presentación de una declaración jurada de causa probable.
Proof evident and presumption great is the highest standard we have in the criminal justice system.
La evidencia de prueba es el estándar más alto que tenemos en el sistema de justicia criminal.
Higher even than proof beyond and to the exclusion of every reasonable doubt.
Es más alto inclusive de la prueba, más allá de la exclusión de la duda razonable.
No testimony has been presented to this court from any witness, either detective or officer or victim.
Ningún testimonio ha sido presentado a esta corte, ya sea de algún oficial, de algún detective o de alguna víctima.
Mr. Bonica's alleged confession or statement to the police has not been played to this court. His confession or statement has not been played to this court, has not been played for the court.
Okay. La confesión o la declaración del señor Barnica a las autoridades no ha sido presentado, no ha sido demostrado.
So based on
por esta corte.
the high standard of proof evident presumption great, we would ask that this court not find that that standard is met and set a bond for Mr. Barnica.
Y basándonos en la regla de la prueba antes mencionada, solicitamos que se establezca una fianza para la detención del señor Barnica.
Mr. Linder, has this case been filed?
It has.
Este caso ha sido presentado.
Yes, it's been direct file. That's why it's here today, Your Honor.
Sí,
It's
se ha
been
sido archivado directamente. Eso
Not
es
just
por lo que está aquí hoy.
direct file, but it's been, and information has been filed.
Yes.
And the case is pending before Judge Dennis Bailey.
El caso estaba presentado frente al juez Bailey.
I don't have the paperwork in front of me, but if that's what the booking sheet shows, yes, then that's
No
what would
tengo
be
los
assigned to me.
documentos para confirmar eso.
All right, and we'll find the state has satisfied its bond and said no bond on count 1 and count 2, counts 3, 4, and 5. I will set bond at $1,000.
Para los cargos 1 y 2 no habrá fianza y para los cargos 3, 4 y 5 habrá una fianza de $1,000.
And this case should be set before Judge Bailey
Y este caso se ha presentado frente al juez Bailey
at the earliest possible setting.
en la fecha más temprana disponible.
Okay.
La-
I've already ruled,
Ya di mi decisión
and I am now calling Gene Polston.
y estoy llamando en este momento al señor Gene Polston. Have a good day, Your Honor.
Oh, thank you, and thank you so much for your patience. I appreciate it. Somehow, I don't think he's going to volunteer for us again. Do we have Mr. Gene Polston?
North
I
Broward.
think he's a medical reset, Judge.
Oh, what's up with that?
Yes, he's a medical reset.
Yeah, he's right.
Reset.
I got quite a few medical resets up here today.
Okay. So Brian McClellan.
Mr. McCollum is here, President Main Judge.
Nope. Sir, good morning. Sir, you have 4 counts that were presented. Each is a capias, failure to appear. And count 1, bond has been set at $500. Count 2, $100. Count 3, $500. And count 4, $100. Okay, sir?
Yes, sir. I would like to reserve this case today. If you read the affidavit, this charge has been on Leon McLaughlin, not to Brian McLaughlin, Steve McLaughlin.
These are 1, 2, 3, 4 different cases, sir. It's not one charge.
Yes, sir. They said it's my alias. I'm using an alias, sir, and I never use an alias. I just get out of jail a few weeks ago, and I've been in jail 3-4 times. If you look in the dates in this case, it says 2016, sir.
Sir, I didn't say it was one case. I said it was 4 separate cases.
There are 4 separate cases, but they're all under Leon McLaughlin and the affidavit with a different date of birth.
Okay, I'll place the case on recall. Hani Farid.
Hey, no, you guys stay in here.
Free?
He's gonna recall you. Yeah, you won't.
All right, Mr. Farid, sir. You have 2 cases. Each has a warrant for your arrest. Count 1 is in the amount of $500. Count 2 in the amount of $100. You also have a status before me on May 3rd at 9 a.m.
I'm sorry, what was that?
You have a status before me. I'm your assigned judge, apparently.
Right.
So I'll see you on May 3rd at 9 a.m., sir.
Do you have an attorney?
All right, is there any way to resolve it today?
And are you your own, or do you want a public servant?
The only paperwork I have right now is the warrants. I don't have the actual cases before me, sir.
You don't have that?
But
All right,
I will,
on May 3rd.
on May 3rd, I will have everything.
May 3rd, maybe we could get everything taken care of. All right. Thank you, sir.
Do you have an attorney, sir?
No, I'm gonna be using a public defender.
Okay, then make sure you fill out the paperwork when you have the opportunity to, so when we get to court, that's already taken care of.
Yeah, I already took care of that.
Okay, I just want to make sure somebody has a chance to look at your case before we get to court on the 3rd, okay?
On the 3rd, all right.
All right.
All right, thank you.
Thank you.
All right, thank you.
And please contact your
All right.
attorney.
All right. Down in the middle outside, young man.
I'm sorry.
May I bring some students in to observe?
Oh, of course.
Okay, thank you.
Michael Maynard?
He's in North
Yes,
Broward,
sir.
Judge.
Mr. Maynard?
Yes, sir.
Good morning, sir.
Morning.
Sir, you have a violation of probation,
Yes, sir.
and bond is set at no bond.
Yes, sir.
Okay, you do have a date on May 1st, 2017, before your assigned judge at 1:30 p.m., sir.
Okay.
Good luck, sir.
All right.
Next is Mr. Richard Knox, Judge.
Before we proceed, I just want to make sure that everyone knows that this room is also being televised. So I want to make sure that that's not an issue with anyone. I don't have a problem with visitors in the courtroom, but I just want to make sure that no one has an issue with the fact that this courtroom is being televised. All right, thank you, and welcome. Mr. Knox. Good morning, sir. Sir, you have one count of trespassing that was presented against you, sir. And I do find probable cause to detain you.
Judge, Mr. Knox is requesting if you would consider resolving his case today for time served.
I'll go after the best.
I would consider resolving his case, but I would not consider a time-served offer based on the numerous warnings in the past. I don't know if he's a candidate for supervision or if that's something he's inclined to accept.
Hold on one second. Judge, respectfully at this time, then he'll try and see if he can post a bond.
Okay, sir, I'm going to set your bond at $100.
Thank you.
Good luck, sir. Lionel Suazo.
He's approaching. He's here. How you doing, sir?
Doing well, sir. How are you?
I'm good.
Sir, you have a warrant for your arrest in the amount of $2,000.
Yes, sir.
Okay, and I do find probable cause to detain you. Bond is set at $2,000, and a hearing should be set before your assigned judge as soon as possible.
So I still got bond? Mm-hmm. Okay, go.
Good luck, sir. Good luck, sir. Brandon Leon Kimbrough.
Judge, I've been advised he bonded. Gene.
Nobody's motoring, man, right? All right. Rodson Dorjin.
He's here present, Judge, I mean?
Good morning, sir.
Good morning.
Sir, one count of possession of paraphernalia has been presented, and I do find probable cause to detain you. Any arguments as to conditions of release?
Nothing from the state.
As to the defense?
One moment, Judge. Nothing at this time from the defense, Judge.
Sir, I'm going to set your bond at $100. Good luck. David James Laura.
Good morning, sir.
Mr. Laura's here present, Judge?
Good morning, sir.
Good morning.
Sir, you have two cases. The present case is resisting without violence. You also have a warrant for your arrest in the amount of $100. I do find probable cause to detain you, sir. In reference to conditions
Judge,
of release.
Judge, respectfully, Mr. Laura is requesting if Your Honor would consider resolving his cases, both of his cases today.
I have animals I have to feed. Tell my have animals.
I'll tell him in a second.
Mr. Romero, this is also a case that you can ask him if he's inclined to accept supervision. The court is concerned with some of the issues that were presented in the last page of the probable cause affidavit. So,
Judge, in that case, would he advised he lives with his mother. He has animals that he needs to take care of financially. His mother nor him are in a position to post his bond. So then, respectfully, would you consider an ROR on count 1 and resolve count 2 on his behalf?
based on the behavior that I've seen, respectfully, sir, no, I will not. And that's the behavior that causes the court concern on that last page of the probable cause affidavit. So I will set bond at $100 on count 1, 100 on count 2. And that's already been set by your prior judge. Good luck, sir. Dwayne Anthony Francis.
Mr. Francis?
Sir. So you have 2 warrants for your arrest. Each is in the amount of $250, and I do find probable cause to detain you, sir. You have a hearing that will be set before your assigned judge. It is not currently set, but it will be set. All right, sir?
Okay, sir.
And again, bond is $250 on each count. Corey Jacob Braddock.
I've been advised he bonded.
Gene Lublin.
He's in Conte, Judge.
Conti.
Good morning, sir.
Good morning.
All right, all I have before me is...
Yes, this is, it's an ad charge, Your Honor. It's been filed, added to in... One moment, Judge. I'm just checking to see.
I can tell you the case number.
You know, I was just checking to see everything he's being held on at the moment.
Okay.
It was added to an ag assault that he's being held on a $5,000 bond on. He's also being held on a robbery firearm, Your Honor, and he's got a $15,000 bond on a separate aggravated battery. Your Honor, I can tell you...
You said $15,000 on the separate aggravated battery?
Yes, Your Honor. I reviewed the information. If you'd like, I could print a copy for Your Honor. The allegation was he struck the alleged victim with a crowbar. In light of the fact that he's got no bond holds already, Your Honor, I was going to be requesting a $7,500 bond. No, and there's already been an order of no victim contact on this case.
Okay, Mr. Reedy?
Well, I don't know how we can make a finding of probable cause.
I was going to ask him to print that out for me.
Okay.
Before I made that
All
determination.
right, so assuming that you find probable cause, I can tell you that Mr. DeJean has been living here for the last 8 years. He is a senior in high school. He's in his 12th year of high school. From what he tells me, before this incident or these incidents that led to his current incarceration, he has no prior criminal history. He says that he has his mother and his father here and he can stay with them. Obviously, bond is not really an issue right now until he goes in front of his division judge, as he currently has a no bond hold. But I'd ask for a lower bond than $7,500 on this case. I've reviewed the information and I see the charging document in count 2 of this particular information is the one that relates to this.
It's on count 2, Judge.
Okay, we'll find probable cause, order bond be set at $7,500. And no contact with the victim. And sir, that no contact with the victim means no direct, indirect, third party, telephonic, electronic contact by any means, sir, okay?
Yes, sir.
Good luck, sir.
Thank you.
Okay.
And Jeffrey Gardner.
It's a medical reset, Judge.
Medical reset.
Albert Angel. Albert? Good morning, sir.
Good morning.
Sir, you have 2 counts that have been presented. One is possession of heroin, and the other one is a violation of probation or community control on case number 110-16782 CF10A. That has a no bond hold on it. In reference to count 1, I do find probable cause to detain you on both counts. In reference to count 1, any arguments as to conditions of release?
Nothing from the state.
No, Judge. Mr. Romero is shaking his head no. I will set bond at $1,000 on count 1 and no bond at count 2. Sir, you have a hearing on 4/27/17 at 9 a.m. before your assigned judge. Good luck, sir.
Oh, sir. Go ahead and see her. Have a seat right there. She's going to call you up. Michael Palmater, come on up, please.
You have an attorney?
Volunteer, good morning, sir. Sir, you have a violation of probation on case number 16000-827 CF10A. And the bond has been set at no bond.
For a violation, this is for a violation of address?
It's a violation of probation on the...
For changing address.
Did I just...
Don't talk about the facts of your case, sir.
If you get into the facts of the case, that can be used against you. Right now, you're being recorded, sir. And for the record, so both counsel are aware, the allegation is that he did violate probation without by changing his address without first procuring consent of his probation officer. As grounds that the offender violated his probation, Officer Danielle Lani states that on or about 3/14/17, the offender did move from his last known address at 1829 Harding Street, Hollywood, Florida, 33020, without the consent of the probation officer, as told to the officer by the offender's roommate on 3/14/17. And
Thank you, Judge.
this warrant was signed by Judge Shear. That is your that's your assigned judge, sir.
So when do I go to court?
So your
May
next
1st,
court date,
8:45
sir,
a.m.
is May 1st at
Perfect.
8:45
Thank
a.m.,
you.
sir. Roderick Vidali.
He's here, present, Judge of Maine.
Good morning, sir.
How you doing, Judge?
Like you could use some green tea yourself, sir. You were stretching just a minute ago. So you have 2 counts that have been presented against you. One is disorderly conduct. The other is violation of probation or community control. Now that has been said at no bond. That's on case number 12006918 CF10A. But the disorderly conduct. Any arguments as to conditions of release on the disorderly conduct?
No, Judge.
No, Judge.
Supervised by pretrial services. That's 6918 for that bird dwelling, as well as 12-17202 CF10A, another burglary on occupied dwelling. Based on the court finding of probable cause, we're gonna act as pretrial taxes for the rule.
Based on the allegations, I'm going to defer ruling on that and allow his assigned judge to address that. And I will
Judge-
set bond on count 1 at $25.
Judge, we didn't hear what pretrial said, and we didn't hear that issue.
The judge is deferring ruling on the motion to revoke his pretrial release, setting bond at $25 and sending him to the division judge.
Thank you, Judge.
Ronald James Folk.
Mr. Folk?
Good morning, sir. You have 2 counts that have been presented. Driving with license suspended and speeding. The driving with license suspended is the 3rd or subsequent offense. And any resolution to that would lead to you losing your license for 5 years.
My license for 5 years.
I do find probable cause to detain you. Is there any argument as to conditions of release?
Nothing from the state, Judge.
Defense?
Nothing from the defense, Judge.
Okay, we'll set bond at $750 on count 1 and RO on count 2.
Thank you.
Are you on a bond or pretrial?
Stanley Porter.
He's approaching.
Those are your charges.
Good morning, Mr. Porter, sir.
Good morning.
Sir, you have 1 count of false identification given to a law enforcement officer, 1 count of parole violation, and another count of parole violation. The parole violations have a no bond hold on each, and the false identification to a law enforcement officer has a recommended bond of $100. I do find probable cause to detain you. Is there any argument as to conditions of release?
No, Judge.
None from the state defense?
No, Judge.
Okay, we'll set bond at $100 on count 1, no bond on count 2 and 3. Good luck,
What
sir.
you mean by? Can I ask you a question, sir? Huh?
You can, but everything you say is being recorded, and the last
Yeah.
gentleman did say something that is probably not in the best
Yeah.
his best interest. So be careful.
Yep. Yeah. When you say parole violation on 2 parole violations, I ain't on but 1 parole conditional release,
Each
and
count.
I violated.
Each count, sir. Each count.
Huh?
You're on parole for 1 case, 2 counts.
What you mean by that?
1 case, 2 counts.
What you mean by 2 counts?
He had 2 charges in that case.
When you were arrested, it was 1 incident, but there was 2 counts on that incident.
And his new arrest, the officer violated his parole based on another
Mr.
charge.
James?
Oh.
What's that?
I can't hear you. The mute is on, sir.
It seems like it's from what I guess pretrial said or someone said. I believe it was 1 count.
Son, we're here.
There's a pending, and there's current.
What do you mean by that?
You have a parole violation.
Right.
Okay, you got arrested on a new law offense.
Yeah, but
Okay, don't talk about the facts. That's what you're here on before the court.
And
But he said
I'm
that
holding you to a bond on the parole violation, sir.
Okay, that's no problem. But what I'm saying, you said I gave the law enforcement officer a false name. I
Don't talk
didn't.
about the facts.
Yeah, I didn't
Don't
do
talk
that.
about the facts.
I did inform you don't have to speak, but everything you say is being recorded, sir. I'm telling you that again.
Got the no bond, so it ain't that.
This is not where you litigate your case, sir.
Where do I go after this? To the parole board?
Mr. Romero can let you know.
Yeah, let me know something, man.
All right, Mr. William Ard. Good morning, sir. Sir, you have 2 counts that were presented against you. Possession of alprazolam, otherwise known as Xanax, and operating a vehicle with unsafe equipment. And I do find probable cause to detain you, sir. In reference to conditions of release, any arguments?
Just to advise the court, Mr. Ard was arrested last Wednesday for reckless driving. He bonded out on a $500 bond and was released last Friday.
Nothing from the defense, Judge.
Okay, having heard no motions, I will set bond at $1,000 on count 1, ROR on count 2. Mr. Romero, you may want to let him know that a motion to revoke may be coming.
Yes, Judge.
Let's see, Guillermo. Rentanazalar. I apologize if I butchered your name, sir.
How are you?
Doing well, sir. How are you? Sir, you have 1 count of corruption by threat to a public servant, and I do find probable cause to detain you.
In regard to probable cause, Judge, I just would like to make the argument that even though the language is offensive, the actual threat itself, I'm going to shoot you and kill you, did not appear as though he had the current ability to carry that out, and there was no indication that he would do it after he was released or if he didn't get released. I mean, there was no bargain for this. It wasn't let me go or something's going to happen to you. It's a threat that he does not have the ability to carry out. So I would argue that there is no probable cause for this charge.
Okay, that wasn't the sole language that was used. So the court does take notice of the language that was used in its entirety, and coupled with the timing of the incident and the lawful duty that was carried out by the law enforcement officer when he was attempting to effectuate the arrest or the investigation when this threat was made. And respectfully, I will find probable cause in reference to conditions of release.
Does pretrial have anything as far as criminal history?
I have a disorderly intoxication in 2010.
That's it.
And loitering and prowling, that was dismissed. He informed us that he does not have a state of residence at this time.
Our state would be requesting a $2,500 bond.
Okay, in defense?
Judge, in speaking with Mr. Ritenalazar, he's 51 years old. Unfortunately, at this time, he's unemployed. Financially, has no money in the bank, no property. He lives in Miami, Judge. No sort of financial resources, anyone to post his bond. I know Your Honor did find probable cause, but for mitigation purposes, I would ask you to consider the argument made by my colleague, and the defense's position is we'd be requesting an ROR.
Okay, I do have a Miramar address that's listed, and that he was born in Costa Rica. It's just been proffered that he lives in Dade County.
He informed us that he lives off and on at
Okay, and so we just reported that he lives off and on at Camilla's house. So at this juncture, there are several different pieces of information in reference to where he resides. So what's been represented to the court, I do have concern with. I will set bond at $2,500 on count one. Good luck, sir.
Thank you.
Hoyt Allen Rowan.
Medical reset.
Reset.
Floyd.
Wait, did you just
Mr. Argaret?
It's a reset.
Mr. Argaret?
Floyd. Hello.
Good morning, sir.
Morning.
So you have two counts that have been presented. One is possession of cocaine. The other one is driving with license suspended, third or subsequent offense. Let's see. I do find probable cause to detain you. Any arguments as to conditions of release?
Your Honor, the state's going to be seeking a bond increase to advise the court. Mr. Argrid is currently out on a grand theft. Additionally, he's got out of Broward 2015 felony theft. One moment, Your Honor. Additionally, he's gone to state prison 2010, grand theft auto, fleeing and eluding law enforcement out of St. Lucie County, 3.5 years state prison. 2005, sale delivery of cocaine out of St. Lucie, 18 months. 86, aggravated assault, 2 years. And I'm showing, Your Honor, showing multiple failures to appear in the past.
Define multiple.
One, two.
More than five?
No.
Not more than five. Okay.
It looks like 3.
Okay. And defense?
Judge, Mr. Argaret is 53 years old. He's been living in South Florida his whole life. Unfortunately, at this time, he's unemployed. Financially, no money in bank, no property. He's going to try and see if he can call a friend. He doesn't think his friend will be able to afford to post his bond. We'd ask you at this time to leave the bonds as they are, the standard bonds on count 1 and 2.
Okay. Based on what I've heard, I will set bond on count 1 at $1,500, on count 2 at $750.
Thank you, Judge.
Lawan Funches.
He's approaching, Judge.
Good morning, sir.
Morning, sir.
Sir, you have a violation of probation on case number 04015653 CF 10B, it appears. And that was signed by Judge Michael Lynch, and the amount is no bond, sir.
All right, sir.
Tariq Searles.
He's here, President Main Judge.
Good morning, sir.
I have a lot of problem with the probable cause in this one, Judge.
Okay, your argument for probable cause is?
Judge, it appears Mr. Searless was never even found in possession of any narcotics, if I'm reading this correctly. It looks like an officer observed a fellow by the name of Ferguson engage in what appeared to be, or what he believed to be, but can't be sure was, a hand-to-hand narcotics transaction in which Mr. Searless allegedly handed Ferguson an unknown item from his front pant pocket in exchange for currency. And later, that substance, if it even is that substance, and there's no probable cause to make the connection between whatever it is that Mr. Searless may have handed to Mr. Ferguson, is the cannabis that was found in Mr. Ferguson's possession later. I think this is a way too bare bones a probable cause affidavit to support a finding in this case, Judge.
State?
Your Honor, that's fine. I'd ask to come back. I can proffer to the court I spoke with Detective Johnson. Ferguson made an admission that Searles, the marijuana he was found with, was delivered to him by Searles.
Okay. How much time did you perfect?
Just that's 24 hours.
24 hours to perfect. Arthur Mitchell.
Aye, sir, you can.
Arthur Lee Mitchell.
He's here, present main judge.
Sir, you have one count of aggravated assault with a deadly weapon. And I do find probable cause to detain you, sir.
Judge, I have a probable cause argument on this case. The only thing that would indicate Mr. Mitchell did anything is it says he intentionally unlawfully threatened to do violence with a glass bottle. It doesn't give us any further details of that, or as to, at least as far as what I'm reading, it doesn't even say that the victim was afraid. It says it created in the victim a well-founded fear, but it doesn't say that that's what the victim said. And just basically saying he intentionally and unlawfully threatened to do violence without any more than that, I would submit is not sufficient for a finding of probable cause.
State?
That's fine, Your Honor. I'd ask for 24 hours.
All right, 24 hours to perfect. Sir, I'll see you tomorrow.
It's reset for tomorrow.
Vernon Ashley. Vernon Tyrone Ashley.
He's approaching, Judge. He's all the way in back. He's in a wheelchair.
What's it?
Good morning, sir.
Morning, Your Honor.
Sir, 3 counts have been presented. Resisting without violence, tampering with physical evidence, and a bicycle regulation violation. And sir, I do find probable cause to detain you. Any arguments as to conditions of release?
One moment, Judge. Your Honor, based on the defendant's criminal history, the state is just requesting that the convenience bond be kept in place. His criminal history, 2014, tampering evidence, resisting without violence, 31 months state prison. 2012, possession of cocaine with intent to sell or distribute, resisting with violence, 31 months state prison as a habitual offender. 2012, delivery of cocaine, possession of cocaine, 31 months. 08, possession of cocaine, attempted tampering physical evidence. He violated probation, sentenced to 13 months state prison. 07, tampering of evidence, just under 14 months state prison. 05, possession of cocaine, VOP, 15 months. 02, possession of cocaine, VOP, 17 and a half months. 89, delivery of cocaine. 84, possession of cocaine, VOP.
Okay. And defense.
Judge, in speaking, Mr. Ashley, I know his family has been trying to bond him out. He's been residing in South Florida his whole life. He is currently employed. He works in flooring. His wages do fluctuate. He has no money in the bank, no property. He lives in Hallandale in an apartment with his with family. Judge, what we'd be asking you to, he's been in custody now ever since the 16th, obviously. He's still in custody, so his family can't come up with the whole amount. We'd be asking you to consider a $500 bond on Mr. Ashley's behalf, and also ask you to sign a photo order allowing us to photograph Mr. Ashley's injuries, Judge.
Okay. I will sign the order for the photographs, but I will set bond, I will ROR on count 1, set bond on count 2 at $1,000, and ROR on count 3.
Judge, I haven't had an opportunity to review the probable cause affidavit. Is this a case that that stems from Mr. Ashley riding a bike, and then as a result of riding of the bike, some sort of bike infraction, that this is where the whole altercation began?
Yes.
Your client has stated on the record.
Could you grab paper for me, please? No.
They did observe, the allegation is that they did observe him riding a bicycle initially, yes.
Then respectfully, Judge, because of that initial...
You're arguing a motion to suppress argument?
No. It's just, I know you've been doing this for quite a while, Judge. You know, potentially down the line, a motion to suppress is going to be coming forward where basically police contact is initiated by some sort of bicycle infraction. I'd ask you to, I know you found probable cause, I'd ask you for purpose of mitigation to consider that and reconsider letting Mr. Ashley out on a $500 bond on count 2.
Okay, respectfully, I will deny that request.
Yes, Judge.
Set bond at $1,000 on count 2. ROR on counts 1 and 3.
We don't need to know more. That's okay.
And
It's under the defense about how.
Trevor Crosby.
Medical reset.
Oh, Mr. Reedy, do we have the photo order on the shooting? Okay. Thank you, sir. You don't. We have 2 more cases. You don't have to rush. Okay. Terrence Johnson.
Conti.
Okay, sir. 2 cases have been presented, or 2 counts have been presented, a battery, second or subsequent offense, and capias on case number 170-03241 CF10A.
What is that?
Your Honor.
Judge, Mr. Johnson wanted to know what the nature of the charge was in that case. The capias charge.
If I may, Your Honor.
On the booking information, it reads, operating a motor vehicle without a valid driver's license.
Yeah.
Well,
okay.
That was one of the counts. But I believe the other count is one of the other counts.
Well, Mr. Johnson's not going to be able to post bond on count 2.
And I'm sorry. Actually, I'm looking at it now. That's what you presented.
Yes, Your Honor.
Okay.
Count 2, when Mr. Johnson came through at his original first appearance, he was charged with misdemeanor battery. He had a prior battery, Your Honor, so the state upfiled the charge to felony battery due to a prior conviction. Your Honor, I can tell you he's being held on a kidnapping on a $500,000 bond.
And that's on count 1.
Yes. Judge Davis, who was informed of his priors and knew about the prior, set the bond on the battery at $25,000. Your Honor, we're just asking that that same bond be reset on him since the court was aware. We're not asking for any kind of increase since the court was aware of his prior record when setting that bond. And the only other condition I would ask, Your Honor, he's already been issued a no contact order on this case number, but there were special conditions, special release conditions, specifically a full collateralization requirement that was placed on the original battery. We would just ask that that special condition be kept in place on the felony battery.
Okay, these are both counts of the same case. Counts 1 and counts 3, is that correct?
Yes, Judge.
Okay. And that is the case that you presented to me with the information with? And that's case number
Yes.
17003241 CF10A?
Yes, Judge.
Okay. And the battery that you're referring to is now, well, here it's a battery as second or subsequent offense, and you filed it as battery prior conviction?
Yes, Judge.
Okay, and the capias is on this case?
It's not a failure to appear. It's just from count 3, just from an add charge. The battery is just a change of charge.
So it's just a change of charge, and the bond was previously set at?
$25,000.
Okay.
Yeah, based on my conversation with Mr. Johnson, Judge, I think it's kind of a moot point right now. He's probably going to have to go in front of his division judge and seek a lowering of the bond there.
Right.
Is there going to be a bond, and if so, what, on the felony DWLS capias?
I think it's just
actually, it was presented as a no valid driver's license, and they're all 3 counts on the same case.
And Judge, I have no objection if you just want to ROR him on count 3.
Okay.
That's fine.
As to the no valid driver's license, I will ROR him, and I will keep the $25,000 bond on the felony battery.
And Your Honor, just for record purposes, if it comes up at a later date, will the court keep the special conditions that Judge Davis originally set?
Yes.
Thank you.
Can they see me? Can they see me?
Yeah, I can hear you.
Oh, okay.
And Your Honor, I can also advise the court, Mr. Johnson is scheduled for arraignment on Thursday morning before Judge Cohen at 9:15 a.m.
Did you hear that, Terrence?
Yes, I did.
Okay, so you're going to go to court Thursday morning, okay?
Okay, thank
All
you.
right. Okay, good luck.
Good luck, sir.
I need it.
Okay, and that was if he should post bond? Okay. Count 1 is a kidnapping. Now that they filed the information, count 1 would be kidnapping.
Yeah. It's always an issue for the charge number on the booking sheet and the charge number on the information.
Okay, and Stephen Chang.
Mr. Chang is here present, Judge, at Maine.
So you have 1 count that's been presented, robbery with a weapon. All right. Defense, any arguments?
Yes, Judge. I think this is a very bare bones probable cause affidavit of robbery with a weapon. For such a serious charge, it's barely a paragraph long. I guess it does say that he approached the victim and pulled out a knife, but there's no indication as to how the knife was used or whether it was gestured at toward the victim or whether it was held over his head or used in a threatening manner or fashion in any way. So I would ask the court not to find probable cause in this case.
Your Honor, I'm sorry. I don't think any argument that's been made goes to whether there's probable cause or not. How a weapon is, all that's required is that a defendant is in possession of a weapon while committing a robbery. It doesn't matter how it's used. He could just be holding it in his hand while committing the robbery. And bare-boned is not, I don't know that is a legal objection of probable cause.
I will find probable cause to detain you, sir, in reference to conditions of release.
Your Honor, defense priors 2011 theft, 2011 3 counts of felony criminal mischief with a violation of probation, 2011 theft, resisting without violence, 2011 theft, 2011 theft, 2010 possession of marijuana. He's before the court today on a first-degree felony. State would be requesting a $25,000 bond and no victim contact.
Judge, and speaking Mr. Chang, he's been residing in South Florida his whole life, 27 years. He is currently employed. He works for AT&T. He's been working for them for about 3 years now. He makes approximately $1,300 a month. Financially, though, he has no money in the bank, no property. He lives in Deerfield with his mother. They've been residing at the same household for the past 27 years. He helps with the expenses and everything like that, so that's why he has no sort of savings. Judge, he's going to be contacting his mother to see if she can help post his bond, but unfortunately, from what Mr. Chang advised me, she really has no income. So therefore, we'd be requesting a $1,000 bond in reference to count 1, Judge.
All right, I will set bond at $10,000.
And we'd ask for no victim contact, Your Honor.
No contact with the victim, so that's no direct, indirect, third party, telephonic, electronic contact by any means, sir. Do you understand that?
Yes, sir.
Okay.
Thank you, Judge.
Good luck, sir. And we had
Mr. McLaughlin.
Sir Brian McLaughlin, sir.
All the cases, they were all NTAs. He was never arrested on it.
Ah.
Oh,
okay. And that's because he indicated this was a Steve McClellan? I'm sorry. Who did he say that?
Right.
He said it was a Steve McClellan?
No.
Leon McLaughlin.
I believe he said that the arrest warrant was in reference to a Leon McLaughlin.
Okay, that does read as one of the aliases on the booking sheet.
From my understanding, also the warrant is referring to a subject who also has a different date of birth than this Mr. McLaughlin.
Right, and the date of birth on that alias is 5/31/1977.
And Mr. McLaughlin
and that is the alias. That's the date of birth on the capias.
My date of birth is 4/5/75.
Okay. All right, and we can have APHIS run a chicken press by tomorrow. Can we have APHIS chicken press by tomorrow? Can we have APHIS chicken press by tomorrow? Okay. All right, so I'm going to reset you for tomorrow.
All right. Thank you, Judge.
They're going to compare your fingerprint.
Compare fingerprints. We're done here at Main, Judge. See you this afternoon.
That's it for the morning docket, is that correct? That's it. Thank you, ladies and gentlemen.